The first clue did not come from a dramatic phone call, a hidden email, or somebody confessing in a parking lot. It came from a court clerk who was tired, overworked, and probably did not realize she had just handed me the loose thread that would unravel one of the most calculated betrayals of my life. My name is Marissa Holloway, and at that counter, in that ordinary courthouse hallway, I learned that Bernadette had secretly filed for divorce from her husband, not because their marriage was falling apart, but because she was trying to move her ownership stake and personal assets into his name before my lawsuit could reach them. I was standing at the civil filing counter, with a folder tucked under my arm, waiting for stamped copies of paperwork in my lawsuit against my business partner, when the clerk glanced at the computer screen and said, almost casually, "Busy week for this name. Your case, and then the divorce hearing too." I remember blinking at her because for a second I thought she had mixed up the files. "Divorce hearing?" I asked. She looked back at the screen, then at me, and lowered her voice a little. "Same party name, scheduled Thursday." She did not say it like gossip. She said it like a person confirming a calendar entry, but the words landed strangely because my business partner, Bernadette Cole, had been posting smiling anniversary photos with her husband barely a month earlier. 15 years together. Still my favorite person. Forever looks good on us. That was the caption. I had seen it while sitting in my kitchen at midnight, reviewing invoices she had refused to explain, and I remember thinking how clean and polished her life looked online compared with the mess she had made inside our company. At the time, I did not know the whole scheme. I only knew something felt wrong in a way I could not ignore. And if you have ever been betrayed by someone who still smiles at you across a conference table, you know that feeling. It is not proof yet. It is a pressure in your chest telling you to keep looking. Bernadette and I had built Cole Holloway Supply together over 12 years. We started with one rented warehouse, 3 employees, a secondhand forklift, and a list of contractors who only gave us meetings because Bernadette had a gift for sounding bigger than we were. I handled operations, purchasing, warehouse systems, vendor contracts, and the endless unglamorous work of keeping orders moving. Bernadette handled sales, investor relationships, and the charm side of the business. In the beginning, it worked. We balanced each other. I was careful where she was bold. She was persuasive where I was skeptical. We fought sometimes, but in those early years the fights were about pricing strategy, delivery schedules, and whether we could afford another truck, not about missing money or hidden accounts. We supplied construction materials across the region, lumber packages, drywall, fasteners, insulation, roofing materials, specialty hardware. Nothing glamorous, but it was steady work, and if you did it well, people remembered. Contractors do not forgive late deliveries, and they do not forget the supplier who saves them when another vendor fails. By our 8th year, we had grown into a respected company with a 42-person staff, long-term commercial clients, and enough profit that both of us were finally breathing easier. I thought that was the reward for all those years of risk. I thought we had survived the hard part. I did not understand that success can reveal a person's character just as clearly as struggle can. The first real crack appeared in our 11th year, when I noticed a pattern of vendor rebates being redirected into an account I had never approved. At first, Bernadette brushed it off as a cash management issue. "Marissa, you are drowning in details," she told me during a budget meeting. "Those funds are still company-related, it is not sinister." I asked for account access. She said she would send it. She did not. 2 weeks later, I asked again. She said our bookkeeper was still reconciling everything. Then a supplier called me directly because he was confused about 2 different payment instructions coming from our office. That was when my concern hardened into suspicion. I pulled what records I could access and found consulting payments to a firm I had never heard of, reimbursements with vague descriptions, and equipment deposits that did not match any equipment in our yard. When I confronted Bernadette privately, she folded her arms and looked at me like I had insulted her instead of asking a legitimate question about company funds. "You are accusing me because you do not understand growth," she said. "You have always been afraid of scale." That sentence stayed with me because it was so rehearsed. It did not answer anything. It made the problem about my personality instead of the money. Over the next several months, every request for documents became a negotiation. Every meeting became tense. Employees started walking around us carefully. Vendors sensed something was off. Finally, after my own accountant told me the gaps were too large to treat as bookkeeping mistakes, I hired an attorney, Priscilla Nakamura, and filed a civil lawsuit seeking an accounting, damages for breach of our partnership agreement, and an order preventing further diversion of company assets. Filing that lawsuit was not something I did lightly. People sometimes imagine business partners turn on each other overnight, but that is not how it felt. It felt like standing inside a building I helped construct and realizing one wall after another had been hollowed out behind the paint. Bernadette and I had attended each other's family events. I knew her husband, Daniel. He was a quiet, agreeable man who taught high school history and rarely came to company functions unless Bernadette insisted. He always seemed happy to stand slightly behind her, smiling while she worked the room. They did not have children, and Bernadette often said the business was the child she had poured herself into. I believed her. Maybe she believed herself too. When we entered litigation, she acted wounded, as if I had betrayed her by asking where the money went. At mediation, she arrived in sharp suits with perfect hair, sat across from me, and spoke in calm sentences about misunderstandings, overreactions, and preserving the company legacy. She never looked scared. That bothered me. A person accused of mishandling hundreds of thousands of dollars should be angry, defensive, maybe even shaken. Bernadette seemed irritated by the inconvenience, like the lawsuit was a weather delay. Then the clerk mentioned the divorce hearing, and suddenly her calm looked less like confidence and more like preparation. I left the courthouse that day with the stamped papers in my hand and sat in my car for almost 10 minutes before I called Priscilla. The parking lot was hot, and the steering wheel burned my palms, but I just sat there staring at the courthouse doors. When Priscilla answered, I said, "I need to ask you something, and I need you to tell me if I am being paranoid." She replied, "That depends. What happened?" I told her about the clerk's comment and Bernadette's supposed divorce. There was a pause on the line. Priscilla was not dramatic by nature. She had the steady voice of someone who had watched many people lie under oath and had stopped being surprised by it. "Do you know anything about marital trouble?" she asked. "Nothing," I said. "Quite the opposite. She posted anniversary pictures last month. They looked happy. She has mentioned Daniel in meetings like everything is normal." Priscilla said, "A happy social media post does not prove a marriage is intact, but the timing matters. We need facts, not assumptions. Divorce settlements can be used to transfer assets. If it is legitimate, it is legitimate. If it is coordinated to avoid creditors, that is something else." Hearing the word creditors made me uncomfortable because I did not think of myself that way. I was not some outside collection agency. I was her partner. I had built the asset she might be trying to hide. But legally, if I had a claim against her, and she moved property to put it beyond reach, that mattered. Priscilla told me not to confront Bernadette. "Do not tip her off," she said. "Let me see what is public and what will become public. If there is a divorce settlement, we need the terms. A genuine contested divorce usually has friction, negotiation, sometimes uneven compromises. A friendly divorce can still be real, but a complete transfer of reachable assets right before or during civil litigation is a red flag. We need someone who can read the financial trail properly." That was when she recommended a forensic accountant named Cornelia Achebe. Cornelia had worked on business disputes, estate conflicts, and fraud cases for years. Priscilla described her as patient, precise, and deeply unimpressed by creative explanations. 2 days later, I met Cornelia in a small conference room at Priscilla's office. She wore a navy blazer, carried a laptop and a legal pad, and asked questions that made me realize how little I knew about the financial side Bernadette had gradually walled off from me. "What is her ownership percentage?" Cornelia asked. 49%, I said. "I hold 51, but major asset decisions require mutual consent under the partnership agreement. Any personal guarantees tied to company credit?" "Yes. Both of us signed on the warehouse expansion loan. Any recent distributions?" I slid over the records I had managed to compile. She looked at them without reacting. If she transferred her personal stake, cash reserves, or claims to distributions through a divorce settlement, we need to know exactly when, for what consideration, and whether she retained practical control. That phrase, practical control, became important later, because Bernadette's scheme depended on pretending paper ownership was everything, while everyday reality told a different story. For the next couple of weeks, I lived in 2 versions of my life. In one version, I ran the company as best I could while locked in litigation with the woman whose signature still appeared beside mine on contracts. In the other version, I quietly waited for divorce records that might reveal whether she was trying to cheat me in a completely separate courtroom. It was exhausting. Bernadette continued attending mediation sessions for our business dispute, and she performed wounded professionalism beautifully. At one session, she sat beside her attorney, folded her hands, and said, "This has been a difficult personal season for me, and I wish Marissa had approached me with compassion instead of accusations." At the time, I thought she was talking about the lawsuit's emotional toll. Now I understand she was planting a vague reference to the divorce without giving me enough detail to question it. I remember looking at her across the table and noticing that she was not wearing her wedding ring. It startled me because Bernadette loved visible symbols. She liked expensive watches, monogrammed bags, polished shoes, anything that signaled success. Her wedding ring had always been part of that display. I glanced down at her hand, then back up, and she gave me the smallest smile. Not warm, not friendly, more like she had seen me notice and was pleased. When the divorce settlement became available, Cornelia reviewed it first. Priscilla called me into her office the following afternoon. I could tell before anyone spoke that the news was significant. Priscilla had a folder open in front of her, and Cornelia was joining by video, her face serious but controlled. "Marissa," Priscilla said. "The settlement is unusual." I sat down slowly. "Unusual how?" Cornelia answered. Bernadette transferred her entire personal ownership interest in Cole Holloway Supply to Daniel as part of the marital property division. She also transferred the majority of her personal savings, her investment account, and her claim to certain future distributions. In return, she appears to have received very little of comparable value. I stared at the folder. She gave Daniel her whole company stake? On paper, Cornelia said. Yes, Priscilla added. The settlement describes it as an agreed division following irreconcilable differences. No contested hearing on valuation. No expert valuation dispute. No fight over the business interest. No meaningful spousal support dispute. It was filed and approved with remarkable smoothness. I felt a cold, heavy anger settle in my stomach. Bernadette had spent months refusing to provide accounting records, accusing me of overreacting and acting like I was trying to destroy what we built. Meanwhile, she had quietly handed her stake to her husband, the very person she claimed to be divorcing, as if that would put it safely behind a wall. Cornelia walked me through the documents line by line. She explained that a business ownership interest can be part of marital property depending on state law, and transfers in divorce are not automatically improper. People divide assets all the time. A spouse might receive a business interest to balance retirement accounts, equity in a home, or other property. But here, there were problems stacked on problems. The timing was directly aligned with my lawsuit. The transfer was unusually complete. Daniel received the assets most relevant to satisfying a possible judgment. Bernadette received assets that were either less reachable or less substantial. The filing contained no sign that Daniel had demanded the stake, no valuation dispute, no negotiation record showing why such a major asset had to move. Most importantly, the settlement did not match the public reality. Bernadette and Daniel were still presenting. Their anniversary photos were still online. Daniel had liked comments congratulating them. Bernadette had commented back to a friend, "He is still the best decision I ever made." Cornelia did not base her conclusion on social media, but she included it as context. "The financial pattern suggests an asset protection motive," she said. "But to strengthen that argument, we need evidence that the divorce is not genuine in substance. Continued cohabitation, shared expenses, coordinated financial behavior, anything showing they remained a marital unit despite the paper divorce." Priscilla nodded. "Which means we need an investigator, carefully, legally, no theatrics." That was how Marisol Vance entered the story. Marisol was a private investigator Priscilla trusted. She was a former insurance investigator, calm and observant, the kind of person who could sit unnoticed in a parked car for hours and remember which porch light turned on at what time. When I met her, she asked fewer personal questions than I expected. She did not care whether I thought Bernadette was evil or whether Daniel seemed weak. She cared about addresses, vehicles, routines, court claims, and what exactly the divorce filing had asserted. According to the documents, Bernadette had moved out of the marital home and was living at a downtown apartment. Daniel supposedly remained in their house. The settlement referred to their separation as already established. Marisol wrote that down and asked, "Do you have the apartment address?" Priscilla provided it from the filing. Marisol looked at it and said, "I'll verify both locations. I will document observations, not conclusions. You need facts a court can use." I appreciated that. By then my emotions were running ahead of me. I wanted someone to say, "Yes, she is lying. Yes, you were right. Yes, this is as outrageous as it looks." But outrage is not evidence. The hardest part of being wronged in a legal dispute is learning to translate betrayal into admissible facts. The surveillance period lasted 2 weeks, though it felt much longer. During that time, I kept working. Trucks still had to leave by 6 in the morning. Contractors still needed answers. Employees still needed schedules. One of our warehouse leads, Tanya, pulled me aside one afternoon and asked, "Are we going to be okay?" I wanted to tell her the truth, which was that I did not know. Instead, I said, "I am doing everything I can to keep the company stable." She nodded, but her eyes stayed worried. That was another part of Bernadette's betrayal that outsiders did not always understand. This was not just about me and her, it was about every employee who had trusted us to run a functional business. It was about vendor relationships built over years. It was about clients who had projects depending on our deliveries. When Bernadette moved money and hid records, she was not just hurting my pride or my bank account. She was gambling with a company dozens of families relied on. And now, if she was using a fake divorce to protect herself from accountability, she was showing exactly how little responsibility she felt for any of it. Marissa sent updates only through Priscilla, and Priscilla kept them sparse until there was enough to analyze. Still, little details began to form a picture. Bernadette's SUV was parked overnight at the marital home repeatedly, not at the downtown apartment. Daniel's car was there too. Lights came on in the primary bedroom at night. Bernadette left the house early in work clothes several mornings. Daniel brought trash bins to the curb and later carried groceries inside, while Bernadette followed him up the walkway with a dry cleaning bag. On one Saturday, they drove together to a home improvement store, bought paint and shelving, and returned to the house. On another evening, they met friends for dinner and left together, with Daniel's hand resting on Bernadette's back as they walked to the car. The downtown apartment, meanwhile, showed almost no signs of occupancy. Bernadette visited it twice during the 2 weeks, both times briefly, carrying no overnight bag. Marissa also documented that the mailbox there appeared stuffed with advertising mail, and that no lights were visible in the evenings she observed. None of this alone would prove everything, but together it contradicted the separation story in the divorce papers. Then came the detail that made even Priscilla exhale sharply. Marissa obtained lawful public utility and property information, showing that the downtown apartment lease had begun only shortly before the divorce filing, and was being paid from an account linked to Daniel. In other words, the supposed separated husband was paying for the apartment. Bernadette claimed as her separate residence. Cornelia tied that fact to bank records already produced in the business case, showing that large transfers out of Bernadette's personal accounts occurred shortly before the settlement was signed. The timeline started to look less like a marriage ending and more like a plan being executed. File divorce. Claim separation. Transfer assets to husband. Maintain real life together. Present the paper trail as a shield if my lawsuit resulted in a judgment. It was audacious because it depended on nobody looking too closely. And to be fair, if not for that clerk's offhand comment, maybe nobody would have. The family court had no reason to scrutinize the settlement deeply if both spouses agreed. My business case was in a different courtroom. Bernadette counted on the separation between systems. She counted on everyone treating divorce as private and business litigation as separate. She counted on me being too overwhelmed to connect the two. The strangest part was having to sit in mediation while this evidence developed. Bernadette still came in composed. She still used phrases like partnership breakdown and unfortunate misunderstanding. At one point, our mediator asked whether both sides had authority to discuss settlement terms involving ownership interests. Bernadette's attorney said, "My client is prepared to discuss appropriate resolutions." I watched Bernadette look down at her notepad, and I wondered if her attorney even knew she had transferred her stake to Daniel. Maybe he did, maybe he did not. Lawyers can only work with what clients tell them, and clients lie to lawyers more often than people think. When the mediator stepped out, Bernadette leaned back and said quietly, "This could have stayed between us, Marissa." I looked at her. The money could have stayed where it belonged. Her expression tightened. You always needed control. I almost laughed because it was such a clean reversal. She had hidden accounts, redirected rebates, blocked records, and transferred assets through a fake divorce, but I was the controlling one because I wanted an accounting. That is how people like Bernadette operate. They turn accountability into aggression. They make your reasonable questions sound like personal attacks. If you are not careful, you waste years trying to prove you are not the villain in the story they wrote to protect themselves. When Priscilla decided we had enough to confront them formally, she did it through attorneys. She prepared a letter laying out the evidence. The timing of the divorce filing, the complete transfer of Bernadette's ownership interest and personal savings to Daniel, the lack of contested divorce behavior, the continued cohabitation documented by Marissa, the apartment lease paid by Daniel, and the ongoing public presentation of the marriage as intact. The letter stated that we intended to seek relief on the basis that the transfer was fraudulent as to a legitimate creditor and designed to hinder collection in my pending claims. Priscilla asked, "Are you ready for the response?" I said, "What response do you expect?" She said, "Possibly denial, possibly outrage, possibly an attempt to settle quickly. But if they are smart, They will understand the transfer is vulnerable. I asked, "Do you think she thought this would work?" Priscilla closed the folder. "Yes, people do not take steps this elaborate unless they believe the risk is worth it. She likely assumed you would not know to look. Most people would not." The response came faster than expected. Bernadette's attorney requested an urgent call with Priscilla. I was not on the call, but Priscilla summarized it afterward. At first, Bernadette's side claimed the divorce was personal and irrelevant. Priscilla replied that personal motive did not protect a transfer made to hinder a pending creditor. Then they argued that divorce settlements are court-approved. Priscilla responded that court approval obtained without disclosure of fraudulent purpose does not make a transfer untouchable. Finally, after Priscilla referenced the cohabitation evidence and the apartment lease, the tone changed. Bernadette wanted to know what it would take to resolve the business case. That was the first sign she knew the divorce shield might collapse. A few days later, during a formal settlement conference, Bernadette appeared without her usual polish. Her hair was pulled back tightly, and she wore no jewelry except small earrings. Daniel came with her, which was almost absurd given the supposed divorce. He waited in the hallway at first, then joined a side meeting with her attorney. I saw him through the glass panel in the conference room door. He looked pale and uncomfortable, not like a man newly empowered by receiving a valuable business stake, more like a man who had agreed to something and only now understood the consequences. We did not settle that day. Bernadette wanted terms that would have let her avoid admitting anything while paying far less than the disputed amount. I wanted accountability, not revenge, but I was no longer willing to accept a number designed around her hidden assets. Priscilla advised patience. "Now we file the motion," she said. The motion was detailed and careful. It did not ask the court to undo Bernadette and Daniel's divorce for all purposes. That was family court territory. Instead, it asked the civil court to treat the transfer of Bernadette's assets as void or voidable for purposes of my lawsuit because it had been made to hinder, delay, or defraud a creditor. Cornelia provided an affidavit explaining the asset movements, the lack of equivalent value, the timing relative to litigation, and the practical effect of placing Bernadette's ownership interest beyond collection. Marissa provided an affidavit documenting surveillance observations, showing Bernadette and Daniel continued living together at the marital home, despite the divorce filing's claims. Priscilla attached exhibits, settlement excerpts, filing dates, social media posts, vehicle observations, the apartment lease information, and relevant financial records. Reading the motion was like reading the architecture of a lie. Every beam was labeled, every hidden support was exposed. Bernadette fought the motion, but her opposition was weaker than I expected. She submitted a declaration saying marriages can be complicated and that continued contact with Daniel did not mean the divorce was fake. That was true in the abstract. Divorced people can remain friendly. Some live together temporarily for financial reasons, some reconcile. But she did not explain why she transferred nearly everything of value to him while receiving little in return. She did not explain why the apartment she claimed as proof of separation was paid for by Daniel and barely used. She did not explain why the divorce proceeded so smoothly at the exact moment my lawsuit threatened her assets. She did not explain why she had never disclosed the transfer in our business case until we discovered it ourselves. At the hearing, her attorney tried to focus on privacy. "My client's marital relationship is not on trial," he argued. Priscilla stood and said, "Her marriage is not on trial, the transfer is. The evidence of continued cohabitation and coordinated finances is relevant because the transfer was presented as part of a genuine marital separation, while functioning as a device to place assets beyond the reach of a pending civil claim." The judge listened without much expression. I sat beside Priscilla, my notebook open, though I barely wrote anything. Bernadette sat across the aisle, staring straight ahead. The judge asked Cornelia several questions about valuation and timing. Cornelia answered clearly. She explained that Bernadette's ownership interest was one of her most valuable assets, that it had been transferred after litigation had begun, and that the settlement did not reflect a balanced exchange. The judge asked Marissa about her observations, making sure everything had been gathered lawfully from public places and permissible records. Marissa was calm, factual, almost plain. She did not embellish. She simply described dates, times, locations, vehicles, and behavior. That plainness made her testimony stronger. Then the judge asked Bernadette's attorney one question that shifted the room. What did Miss Cole receive in exchange for transferring her business interest? Her attorney gave a long answer about global marital resolution, emotional closure, and non-monetary considerations. The judge repeated, What asset of comparable value did she receive? There was no good answer. Bernadette looked down at her hands. Daniel, sitting behind her, rubbed his forehead. I felt no triumph in that moment. I felt tired. I had wanted my partner to explain company funds, not to sit in court proving her divorce was a financial maneuver. The court did not rule instantly from the bench. The judge took the matter under submission, which meant more waiting. Those days were some of the longest in the entire case. I would wake up at 4 in the morning thinking about possible outcomes. What if the judge said the divorce settlement stood? What if Bernadette's paper transfer worked? What if our business claim became a hollow victory, a judgment with nothing behind it? I tried to keep routines. I walked the warehouse floor. I reviewed purchase orders. I answered emails. But my mind kept returning to the same image. Bernadette smiling in anniversary photos while quietly preparing documents to move her assets away from me. I also thought about Daniel. It would be easy to cast him as a passive spouse dragged into her scheme, but he signed the settlement. He paid for the apartment. He accepted the assets. Maybe Bernadette designed the plan, but Daniel participated. That realization mattered because betrayal often has assistance. Some people do not create the fraud, but they make room for it, benefit from it, and then look uncomfortable when the light hits them. When the ruling came, Priscilla called me first thing in the morning. I was in my office with a cup of coffee I had not touched. "We won the motion," she said. For a second, I could not speak. She continued. "The court found sufficient evidence that the transfer of Bernadette's assets to Daniel was made with intent to hinder or delay your claims. The transfer is void as to your lawsuit. Her ownership interest and transferred assets can be considered available for purposes of satisfying any judgment." I closed my eyes. The relief was physical. My shoulders dropped like I had been carrying weight I had forgotten was there. "Does that mean the divorce is undone?" I asked. "No," Priscilla said. "The court is not invalidating the divorce itself. It is refusing to let the asset transfer defeat your claim. That is the remedy we needed." I thanked her, then sat quietly after we hung up. Outside my office window, a flatbed truck was backing into the loading area. The same ordinary business noises continued. Engines, metal doors, forklifts, someone calling out a delivery number. The company had kept moving while Bernadette tried to move the ground underneath it. The ruling changed everything. Once Bernadette understood the assets were no longer safely hidden, her appetite for litigation disappeared. Settlement talks resumed with a very different tone. This time, she did not speak about compassion or misunderstanding. Her attorney spoke numbers. Priscilla and Cornelia evaluated those numbers against the missing funds, the disputed transactions, the cost of continued litigation, and the likelihood of recovery. I had to make a decision that was less emotionally satisfying than a dramatic trial but more practical for the company. We settled. Bernadette agreed to pay a substantial amount, relinquish any management role, cooperate with a final accounting, and sell her ownership interest under a structured buyout that reflected offsets for the disputed funds. The settlement also included strict representations about asset transfers and enforcement provisions if she failed to comply. Daniel was required to sign documents acknowledging that he would not assert ownership rights in the company's stake against my claims or the buyout structure. It was not the public confession some part of me wanted, but it was enforceable, and it protected the business. Sometimes accountability looks less like a speech in court and more like signed documents that finally stop the bleeding. After the settlement, I spent months cleaning up the damage. We changed banking controls, vendor rebate procedures, approval thresholds, and record access. No single partner could redirect funds without dual authorization. Every rebate had to be logged against the originating vendor contract. Outside bookkeeping review became mandatory quarterly, not optional when someone felt like cooperating. I also restructured the partnership agreement with Priscilla's help, even though Bernadette was leaving, because I never wanted to rely on trust where a written control should exist. The revised agreement included provisions addressing transfers of ownership interests, marital property claims, creditor avoidance, related party transactions, and disclosure obligations during litigation or buyout disputes. It sounds excessive until you have watched someone use a divorce settlement as a hiding place. Then it sounds like basic hygiene. I learned that a business agreement should not be written only for the partner you think you have on the best day. It should also account for the partner they might become when money, fear, and consequences close in. Cornelia said something near the end of her work that stayed with me. We were sitting in Priscilla's conference room after reviewing the final accounting, and I asked her how common this kind of sham divorce was. She said, "Not common, but recognized." People sometimes use divorce settlements because they look ordinary from the outside and because courts do not always scrutinize agreed divisions deeply. A direct transfer to a relative before a judgment raises obvious questions. A transfer inside a divorce can appear legitimate unless someone connects the timing, the value, and the reality of the relationship. Then she added, "Fraud often wears the clothing of normal paperwork." That sentence perfectly described what Bernadette had done. She did not forge a wild document in a back room. She used respectable systems, court filings, settlement language, asset schedules, leases, signatures. She relied on the dignity of those systems to discourage suspicion. And for a while it worked. People saw divorce papers and assumed private pain. They saw asset division and assumed marital compromise. They saw a business lawsuit and assumed an ordinary partnership fight. Only when the pieces were placed beside each other did the picture become obvious. I have been asked whether I ever confronted Bernadette personally after everything ended. The answer is yes, but not in the explosive way people imagine. Several weeks after the settlement was signed, she came to the warehouse to collect personal items from her old office. Priscilla had advised me not to be alone with her, so Tanya stayed nearby with the door open. Bernadette packed framed certificates, a glass award from a supplier, and a few books into a box. For a while, neither of us said anything. Then she looked around the office and said, "You got what you wanted." I could have said many things. I could have listed the missing funds, the fake divorce, the lies, the months of stress. Instead, I said, "No, Bernadette. I wanted the partner I thought I had." She looked at me then, and for the first time in a long time, I saw something like shame cross her face. It passed quickly. "You never trusted me," she said. I shook my head. "I trusted you for years. That is why this worked as long as it did." She picked up the box and left without answering. I do not know what happened to Bernadette and Daniel's marriage afterward. Publicly, they stayed quiet for a while. The anniversary posts disappeared. The divorce remained on record, but I heard through mutual contacts that they were still seen together often. Maybe they reconciled officially. Maybe they never truly separated. Maybe the legal status mattered less to them than the failed purpose behind it. I stopped checking. At some point, watching the people who hurt you becomes another way of staying tied to them, and I had a company to rebuild. What mattered was that the asset transfer did not work. The court saw through it. The business survived. My employees kept their jobs. Our vendors stayed with us after some difficult conversations. Clients who had worried about instability came back when deliveries continued and invoices made sense again. Trust returned slowly, not because I asked for it, but because we operated consistently over time. The personal lesson was harder. For months after the settlement, I questioned my own judgment. How had I missed the signs? How had I let Bernadette wall off financial information? Why had I accepted delayed explanations for so long? Priscilla told me something blunt but kind. Trust is not stupidity. But once trust breaks, controls matter. I needed to hear that. It is easy after betrayal to rewrite your past self as naive. But that is not always fair. I had trusted a partner because trust is part of partnership. The mistake was allowing trust to replace verification as the company grew more complex. In the early days, we could see every invoice because there were not many. By year 12, systems had to do what personal familiarity could no longer do. Bernadette exploited gaps that success had created. That is painful to admit, but it is also useful. Pain that teaches you where the locks belong is not wasted. If I could go back to the day the clerk mentioned the divorce, I would still pause in that courthouse parking lot. I would still feel that strange pressure in my chest. But I would tell myself that suspicion is not the same as bitterness, and asking for proof is not cruelty. Bernadette wanted me to feel guilty for looking. She wanted the privacy of marriage and the complexity of business law to create enough fog that I would back away. I am grateful I did not. One quiet comment from a court clerk led to a forensic accountant, a private investigator, a motion, a ruling, and ultimately the unraveling of a plan designed to make my lawsuit meaningless. That is how accountability sometimes happens, not in one grand revelation, but through small facts patiently gathered until the lie can no longer hold its shape. So that is my story. My business partner secretly filed for divorce from her husband, to move her company stake and savings into his name, hoping to shield them from the lawsuit I filed after she mishandled company funds. She counted on the divorce looking private and legitimate. She counted on me not connecting the timing. She counted on paper being stronger than reality. But the records, the money trail, and the simple fact that she and Daniel were still living as husband and wife told the truth. If you were in my place, would you have suspected the divorce right away, Or would you have dismissed it as a personal matter and focused only on the business case? Share what you would have done, because I think a lot of people underestimate how ordinary fraud can look from the outside. Thank you for listening to my story. If you want more stories about betrayal, hidden money, business disputes, and the long road back to accountability, subscribe for the next one. Take care of yourself, and trust your instincts when the details stop adding up.